Welcome back to the Friday Five for July 19th, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. Today we take a quick look at 5 questions from the week. We try to get them answered in about 5 minutes. Maybe these are things that you've wondered about in the past. So let's get started with question number 1 this week. Am I personally liable for corporate debts? So this was kind of a sad story I heard from a prospective client about. He had gone into business with a family member. He didn't realize that the family member wasn't really committed to the business. And in the end, the family member ran the business into the ground, left and disappeared. And now he's stuck with a variety of corporate debts and is not sure what to do with them next. Now, the challenge we have in this case is that he and the family member didn't actually do an operating agreement, didn't put any documents in place. All they did was file for their LLC with the state of Minnesota and then just started running a business. So in this case, we have to make sure that we have the business properly set up so we can avoid any liability for corporate debts. Now, the challenge he may have is there may be tax implications for him personally, but as far as, basic contracts between the business and other entities, as long as there's not a personal guarantee, he should not be liable for those debts. But again, without paperwork, we might have a bit of a headache and a lot of work to do as we move forward. Question number 2 this week. What happens when my LLC doesn't have an operating agreement? And this is a follow-up from that same call. And so without that operating agreement, we don't have any procedures in place for what to do when we have this dispute. We don't even know technically who really were the members of the LLC. All we know is that it was set up with the state of Minnesota, and that there's a basic filing with a registered agent listed. But beyond that, there's really no proof of who owned the LLC, who would be liable for the debts. And in the case of we need to break up the LLC, we don't have a process for who's a member and how their shares get disassociated and get removed from the LLC. So because we don't have any operating agreement, we've now left this prospective client with a lot of legal work to be done, because the way to unwind all this is going to have to be a court proceeding where one party is going to have to file a lawsuit against the other. And the challenge is going to be that the other party, who's pretty much walked away from the business, probably won't even show up in the lawsuit. And we're going to have to do a lot of work in the hopes that we can get these matters resolved. Question number 3 this week. Can my landlord just change my office lease? So in this case, we have a small business that's in a building, and he's having some concerns with the office space and wants to move to a different space. And the landlord announced that we'll just move you to a new office space. Don't worry about it. We'll keep you with the same lease and things are fine. My client said, wait a second. If I'm moving to a smaller office space, the rent should be different. And so the landlord said, okay, we'll just change the lease. Don't worry about it. This is a big red flag if you're dealing with this for your own business. We don't want to say we just deal with it. We want to see in writing what that just deal with it means. So in this case, we're going to get an updated lease. And the question is whether it's a new lease for a new term of time or whether it's the old lease that's being modified or assigned for a different office space location. But especially when you're dealing with corporate real estate, when you're dealing with an office for your business, you want to make sure these dealings are in writing. You don't want a lease for a space that when there's no actual lease. I have other clients who are trying to deal with just an oral lease saying, we'll just agree orally. We agree, talking it out. Here's the lease. Here's the amount and here's how long. Problem is if there comes a problem with the space, you have no written lease to deal with. And so in this case, whether it's that client or whether it's the client that's moving office space, we want to make sure that we have a clear writing indicating what that new lease says. Question 4 this week, and it's a pretty common one I get. Can I transfer my house to a trust? And the simple answer is yes, you can. And this caller was concerned because he had a house and another property he was moving into a trust, and he was worried about it triggering the due on sale clause. Now, luckily for you, there is a federal law, the 𝙃𝙀𝙍𝙀𝙍 Act, that says that when you do that transfer into a trust, it does not trigger the due on sale clause. Now, we need to contrast this with when we are putting a property into an LLC to rent it out. In that case, that transaction may trigger your due on sale clause with your mortgage lender. So the answer that you want to look at is whenever we're changing title to a property that has a mortgage lender attached to it, whether it's a mortgage, some other kind of HELOC, we want to make sure that we are talking to the lender and explaining to them about the transfer. Now, what I've learned from speaking with other mortgage lenders is that many times they don't necessarily ever check on whether the property has been transferred into a different name, and so they don't usually call in the due on sale clause. But there's still that possibility that there might. And being a lawyer, and we have a pretty conservative profession when it comes to this. We want to make sure you know about the risks before you just transfer title into a different name. And question 5 this week, can my trust own out-of-state assets? This was a very interesting call because this caller had actually spoken to a couple other attorneys who said that the trust could not own out-of-state assets. And this was confusing because it's a very common way we set up trusts. So people will own land in maybe different states, maybe in an LLC, maybe not. And the question is, can we put those properties into a trust in a different state, usually the state where the person lives? In my experience, in the states where I practice, it's very common that we have an out-of-state property put into our local trust. However, in this case, for some reason, some other attorneys had told this caller, no, you can't do that. And it's one of those situations where it's important to have a network of professionals to ask, because I reached out to other attorneys in the states that were affected by this property, and each of them in these other states said, of course they can do that. That's not a problem, and we're not worried about it from the foreign state, so your local state should be able to do it. So it shows that it's important to speak to an attorney and understand what goes into the process and whether or not you can do that particular type of trust and ownership of out-of-state property. But generally, your trust can own out-of-state assets. There, of course, may be exceptions, and so I encourage you to speak to a local attorney who is knowledgeable about estate planning, who knows trusts, and can explain to you why your trust can or cannot own out-of-state assets. So that's our 5 questions for the week. If you like this video, you can hit the like or the thumbs up button below. You can subscribe for future episodes on YouTube or go to ayerslaw.tv.com. You can also submit a question for future episode in the link below. You can always go to my website, 𝙃𝙀𝙍𝙀𝙁.com. There's a link at the top where you can set up a strategy session to discuss your legal issues and some questions you may have. Wherever you are, I hope you have a wonderful weekend.